I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on New England state courts. This lesson is the latest of many provided by NEFAC that explore state freedom of information laws. We want you to know how to access government information, and these lessons are the best place to start. If you haven't already, please check out our classes on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. All lessons are at nefac.org/FOI guide. They're also on our YouTube channel, 5 Freedoms. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. The Society Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar. Now, this session is going to focus on state courts in Vermont. And with us is Hillary Rich and Harrison Stock, and they're staff attorneys at the Vermont ACLU affiliate. And they're going to give us a general overview of how the courts work in the Green Mountain State. Thank you guys, Hillary and Harry, for joining us today.
Yeah, thanks so much for having us. So like I said, I'm Hillary Rich, staff attorney with the ACLU of Vermont, here with my colleague, Harry Stark, to discuss with you all today accessing Vermont courts and court records. So since this is the first in a series of presentations that will become more in-depth as they progress, Harry and I are going to be giving you a general overview today of a few points. We're going to be discussing how the Vermont state court system works, including court structure, what court handles what matters. I'm also going to be discussing the rules that are in place for accessing hearings, so the constitutional bases and the judicial policies. And then Harry's going to be covering how to access court records and the rules associated with that. And we'll also have time at the end to answer any questions that you might have. So first, I wanted to give you a broad overview of what the Vermont state court system looks like. So unlike the federal court system that has 3 levels, the Vermont state courts are a little unique because there's only those 2 levels. So at the first level is the Vermont trial courts, also called Vermont superior courts. And you can see then right above that is the Vermont Supreme Court. So Vermont, again, because there's only these 2 levels, parties actually have an automatic right of appeal from the Superior Court to the Vermont Supreme Court. And you can see on the slide that there's sort of a range of different positions that are appointed, elected, or staffed by state employees. And now we're going to be discussing kind of those 2 levels in more detail. So looking first at level 1, the Vermont Superior Courts or Vermont trial courts. Each of Vermont's 14 counties actually has its own superior court that's divided into different divisions, and they handle different kinds of cases. So the chief superior judge assigns a presiding judge to each of the units, and judicial assignments last for about a year. And so that means that throughout the course of your case, your judge could actually change. So looking at the specific divisions, there is a civil division that handles civil matters like land disputes, foreclosure, medical malpractice, breach of contract, eviction. And there's also a small claims court that handles claims under $5,000. This is where the ACLU does most of its litigating, bringing civil rights actions. There's also a family court, and they handle the stereotypical, family matters like divorce, civil union dissolution, separation, child support and custody, and parentage. This is the court that also determines how the state will care for people who have mental illnesses and developmental disabilities. There's a criminal court that does the misdemeanors and felonies. They also have special treatment courts that deal with drug issues specifically. And this is the court that also approves or declines like search and arrest warrants. There's the probate court, and conceptually there seems like there's a little bit of overlap with the family court, but they are separate divisions. Probate court specifically handles emancipation, adoptions, guardianships, death, birth, and marriage records, and the probate of estates, trusts, and wills. The environmental court obviously handles environmental law. And there's a judicial bureau that covers cases relating to civil violations. So things like traffic courts and municipal ordinances, that happens with the judicial bureau. So not only does each court have its own type of case that it oversees, but they also each have their own rules and their own filing fees. The Judicial Bureau, $65, Civil Division, $295. So quite a range when you're going to court. So let's say a party is dissatisfied with their outcome at Superior Court. They then can appeal to the Vermont Supreme Court. There are 5 justices on the Vermont Supreme Court, 1 Chief Justice and 4 associates. They become a justice by being appointed by the governor and then confirmed by the Vermont Senate for a 6-year term. And actually, each of these justices was recently reappointed for another 6 years. The duties are listed on the slide. They include handling appeals from the lower courts. Also, they deal with appeals from state and municipal agencies. Cases are heard either by 3 justices or the full 5, and then they'll issue written decisions. This court also creates rules for procedure. They manage the court system, and they oversee attorney admission and the discipline of all judges and attorneys licensed in Vermont. So now that we've covered, what court does what, let's talk more generally about how you have rights around accessing these courts. So the public and the press do have a qualified right of access to court proceedings. And what that means is there is a right to access, but that right is not limitless. The right is primarily grounded in the First Amendment, and the US Supreme Court has explicitly held that the press and public have a First Amendment right to attend criminal proceedings. So the Sixth Amendment right, you may be aware, gives people a right to a public trial, but that right attaches just to the accused. It doesn't really vest any rights in the press or public. So when we're talking about the public and press, we're usually talking just about the First Amendment. So although the First Amendment doesn't explicitly mention the right of access to the court, the US Supreme Court has held that the right to attend criminal proceedings is really implicit in free speech, and it serves an important function in a democratic society to make sure that trials are fair. And this is really a long-standing right that goes back to colonial days, but the Supreme Court only acknowledged it first in the 1980s. And first they found a right to attend criminal trials, and later they expanded that right to attend jury selection and preliminary proceedings. Now, the Supreme Court has never actually recognized a right of access to civil proceedings, although several states and lower federal courts have. But in Vermont, most criminal and civil hearings are open to the public. So there's no comprehensive rule or statute governing public access to court proceedings in Vermont, but the Vermont Supreme Court has repeatedly recognized the generally accepted practice, as well as the public's constitutional and common law right of access to court records and to court proceedings. So therefore, Vermont court proceedings are presumptively open to the public, with closure being the exception rather than the rule. And both of these quotes are from a case called State v. Tallman, which was before the Vermont Supreme Court in 1987. Now, in that case, a defendant had been accused of murder and asked the court to actually just seal the probable cause affidavit and close the courtroom during a suppression hearing. And the media actually intervened in that case and went before the Vermont Supreme Court, and the Supreme Court sided with the media. They said it was wrong for the media to have been denied access without the defendant having really presented any evidence of why closure was necessary. So generally, we see that there is a presumptive right of access to the courts in Vermont, and typically you don't need to request access for criminal, civil, or appellate proceedings. There's the caveat that for remote hearings, you might need to request the link from the court administrator, but they should not make you jump through any hoops to attend in person or remotely. But let's talk about exceptions. So we can see in some of these exceptions and in court decisions, they recognize that the First Amendment rights are really important, but there is some tension with other rights at stake. We want to ensure that a defendant has an unbiased jury. We want to protect witnesses. We want to make sure that juvenile offenders are receiving rehabilitation and that their privacy is respected. So there are specific exceptions to the rule of presumptive access. One of those exceptions is for grand jury proceedings. Although there is a presumptive right to access jury selection, grand jury proceedings themselves are closed. And there's actually a statute that defines who is even allowed to be in the room during grand jury proceedings. Jurors themselves have to take an oath to keep their deliberations in grand jury proceedings secret. There is Also, a statute that closes the court during juvenile court proceedings. A Vermont statute actually prohibits even publicizing a child's involvement in juvenile justice proceedings without their consent. And as of July 1st, 2018, anyone who is 21 or younger who is charged with a crime in Vermont can petition for something called youthful offender status. At that point of the petition, records are transferred from criminal court to family court. And the case is confidential until that family court judge makes a ruling on whether youthful offender status applies. At that point, if they say this case deserves youthful offender status, it remains confidential. If not, it goes back to criminal court where it's fair game for public access once again. But there are situations in which a party might want the court closed, but a statute doesn't apply. And it is very difficult in Vermont for a party to get the court to close. To resume the presumption of openness, a party seeking closure has to demonstrate that closure is essential to preserve higher values or a compelling interest, and that closure is narrowly tailored to serve that interest. So before closing a proceeding, a trial court must exhaust all reasonable alternatives to closure and make specific findings detailing the need for it. Also looking at prior restraints or so-called gag orders, similarly, very high burden. The US Supreme Court and Vermont courts agree gag orders are extremely disfavored. The Supreme Court of the US has actually said that prior restraints on speech and publication are the most serious and least tolerable infringement on First Amendment rights and are presumed to be unconstitutional. Vermont courts agree. In a case where they actually rescinded a prior restraint order, they held that these orders were inappropriate except under the most extreme and compelling circumstances, and that any order must be narrowly tailored to cover only the improper disclosure that would occur in the absence of an order. So a very high bar to clear. So now that you've made it into the courtroom, let's talk a little bit about the recording rights that you have once you are there. Actually, the courts in Vermont recently adopted some new rules related to this, specifically Rule 79.2, that covers possession and use of recording devices in a courtroom. And they divide sort of attendees into different categories. There's different rights that attach if you're a member of the media, if you are a participant or like a party, or if you're just a non-participant, non-media who's there to observe. And so these rules apply in both the civil and criminal context. On the slide, the language is taken from the civil rules specifically. And this states that for the media, media obtain a permanent or a one-time registration certificate that allows them to orally and visually record and transmit when they're in the courtroom. The rule also includes how you get that certificate. It's not supposed to be difficult at all. The rule also has a section that discusses if there are multiple media present who want to record, there can be an area that's specified for them, and they sort of have to duke it out amongst themselves how they want to pool coverage at that point. There are also rules for parties and for non-participants. Generally, a non-participant member of the public, they can possess a device, but their use is much more limited, but all those are specified in that Rule 79.2. So overall, in terms of access, there's this really strong and court-recognized societal interest in public trials. The Second Circuit, which is the federal court that covers Vermont, has explicitly stated that openness in court proceedings may improve the quality of testimony, induce unknown witnesses to come forward with relevant testimony, cause all trial participants to perform their duties more conscientiously, and generally give the public an opportunity to observe the judicial system. So this presumption of access is recognized as an incredibly important right that benefits not only the trial itself, but also society at large. And now I'm going to hand it over to Harry to be covering court records specifically.
Thanks so much, Hillary. Really appreciate it. And thanks, Emily. Thanks, Justin, and the rest of NEFAC for having us here today. We're really thrilled to talk to you all. So Hillary has given you a comprehensive overview of the types of courts and the way that the court system works here in Vermont. I'm going to talk very generally about court records and essentially how to think about access to court records. There are a number of exceptions and details for specific records, much like the Public Records Act. And so what we're hoping to cover today is just a very high level overview of sort of how you should go about thinking about whether or not a particular type of record is publicly accessible, where you might go, who you might ask to get that record. So in terms of just the background rule, much like the public access to court proceedings themselves, citizens have a constitutional and common law right of access to court records. That derives from the same case that Hillary just talked about. Interestingly, in the way that that right is effectuated, it's not actually effectuated by statute, but by something called the Vermont Rules for Public Access to Court Records. And that's a comprehensive set of rules of access to court records that's created by the Vermont Supreme Court. What's important to note here is that this is not actually covered by Vermont's Public Records Act, which is a little bit confusing because for those of you that are familiar with the text of the act actually says it applies to any branch of Vermont government. Of course, the judiciary is a branch, but the Vermont Supreme Court has made clear that the Vermont Rules for Public Access to Court Records is actually the authority that governs access to court records. And so for any specific question or any particular type of record that you're seeking, the place to look, if you can, is within the Vermont Rules for Public Access to Court Records themselves. In terms of background presumptions and background rules, the bottom line policy in general is that court records should be open to any member of the public for inspection or to obtain copies. What that means is that any member of the public can show up and request access to a publicly accessible court record without showing identification and without showing a particular need for the record. As we'll talk about in a minute, public access is not necessarily synonymous with the ability to obtain a record anywhere or remotely, but it's a question of who essentially has a right to seek the underlying records themselves. And the answer is that absent a particular provision or a particular rule saying that those records are not available, any member of the public shall be allowed to access a record for inspection or to obtain copies. And if you're wondering what types of records are publicly accessible versus which records are presumptively withheld, the good news is that essentially that tracks the rules that Hillary was just talking about. And so if you have access to a proceeding, you almost certainly have access to a record of that proceeding. And so the rules are essentially the same. If you can be in a courtroom to witness a particular event or a particular proceeding, you should be able to obtain records from that proceeding. We can move to the next slide, please. Again, there are exceptions to this presumptive access. Some of this tracks very closely the types of proceedings which are not public. So as Hillary talked about, these are juvenile proceedings, these are grand jury proceedings. In addition, there's a couple of very particular subject matter areas which are essentially walled off from public access. This includes essentially any proceeding about mental health or competency, as well as attorney discipline. In addition, there are particular types of information that if they appear in a record that is otherwise public, there's a duty to redact that information. And so folks are probably familiar with these categories of information from Freedom of Information Acts or Public Records Act. These are things like personal identifiers for juveniles, social security numbers, passport numbers, and the like. And so even if you have access to a particular record, the court administrator has the right, and in fact, the duty to redact that information before providing that record for inspection or for copying. Next slide, please. All right, so now that we've talked a little bit about what kinds of records are accessible, how do you actually go about getting them? And if you want a physical record and sort of where the underlying original resides is with the custodian in the court office where the record was filed. So this means that going back to what Hillary was talking about earlier, for any particular case, the first thing to find out is what kind of court was this filed in and where geographically was it filed. That's where the original record's going to be. And if you want a physical copy, that's the place to go. The custodian is almost always the clerk of the court, which means that they're open for business hours anytime that the court is open, and you just go to the clerk's office as if you were filing a complaint or you were filing an action and you request public access to a particular record. The one kind of large exception, which I think is actually a bonus for tracking down particular records, is that a number of older records usually reside with the Vermont State Archives. Almost anything from pre-1945 is likely to be there. And without involuntarily signing up a number of state archivists for to assist with any records requests. My personal experience is that in general, they've been extremely enthusiastic, very helpful, and are just subject matter experts in terms of where particular records might reside. So for anything older or anything a little bit unusual, if you call up the Vermont State Archives and you speak to an archivist, they can probably tell you whether or not that record exists in the state archives or where you might go about filing it. In terms of accessing physical records, you can do it anytime that the court is open, and that applies equally to civil and criminal records. So any record in which you might be able to sit in a proceeding and you have a presumptive right of access, you can get that physical record from the clerk of court. Next slide, please, Hillary. Thanks so much. And so now I want to talk a little bit about electronic records. And I think what's critical here is that there's a difference in terms of the way that the rules talk about electronic records and remote access to particular dockets. So I think when most of us think about electronic access to court records, we think of something like the federal PACER, the public access to court electronic records, which means that you or I sitting at home in front of an internet connection can essentially log on and view these records as if we were there in person. And that's not actually the case in Vermont. In terms of civil dockets, any of those can be accessed remotely. So you can go to something called Odyssey, which is essentially Vermont's equivalent of PACER, and you can look at any docket for a civil case under Odyssey. But for criminal dockets, you can't actually access that information remotely. Instead, you can access it electronically, which means you can access it at a public access terminal in a courthouse. And the difference between a public access terminal in a courthouse and actually going to physically inspect the record from the clerk's office is that any one public access terminal in one courthouse is connected to the electronic records in others. And so, for example, if I wanted a particular criminal record in, say, Windsor County, I could go to a public access terminal in Chittenden County and get that information. But unfortunately, none of that information is available remotely in the same way that it is on PACER. So in terms of just rules of thumb, civil dockets, you can access them remotely anywhere. Criminal dockets, you should probably plan on going to a courthouse and finding a public access terminal if you're not going to go to the courthouse in which the case was filed. Next slide, please. All right, so what happens once you actually get there? As I mentioned, anyone can inspect the records free of charge, but if you want to take a copy home and you need staff time to help find a record, you may have to pay for that. And those fees and those fee provisions are borrowed from the Public Records Act. If you're seeking a record and either the custodian won't give you the record or redacts part of the record that you think has been unlawfully withheld, you have 7 days to appeal that. And what you do is you essentially file a piece of paper with the presiding judge of the court in which the case was filed. So that means even if you're looking at the record in a different county, you want to be filing that appeal in the county in which the record, the physical record, is held. If you're dissatisfied with the way that the presiding judge handles that appeal, you then have 30 days to file an action with the Vermont Supreme Court.
Harrison and Hillary, I want to thank you so much for giving us a great walkthrough, a general overview of the state court system. And thanks to everybody who tuned in live. I appreciate it.
Thanks so much. Happy to be here.
All right. Thank you, guys.
Thanks again.